Good morning or good afternoon to where you're joining us from, and welcome to our first ever Third Wednesday webinar. My name is Daniel Johnson, and I am the Director of Marketing and Customer Experience here at MyHR Council. We really appreciate you for taking the time to join us today. Before we get started, I just wanted to remind all of you that this webinar is being recorded, just in case you need to drop off or step away for whatever reason, or if you wanted to watch it again at a later date, feel free to do so. We will be sending an email tomorrow, and that email is going to include the webinar recording, the slide deck, as well as a reference code for HRCI recertification credit. As a reminder, we do also post all of our past webinars on our YouTube channel. You can access that by going to our website on the footer. There'll be a link to YouTube. Otherwise, just by searching MyHR Council on YouTube. And now I'm pleased to introduce our speaker today, our attorney, Britt Waterman. Britt, thank you.
Hi, thanks, Daniel. So today we are going to talk about legally enforcing your attendance policy and some of the pitfalls that you need to watch out, some of the obstacles that you will stumble over when you try to enforce your attendance policy and do so without running afoul of the law or risking a claim. So we're going to talk about attendance policies and then some of the laws that get in the way: FMLA, ADA, pregnancy leave, paid sick leave, and some of the other lesser known types of leave that affect attendance. So why have a formal attendance policy? A lot of times when I hear about major attendance problems, I think, that's less of an attendance problem than it is a hiring problem or an employee or company culture problem. I get clients who contact me claiming that all of their employees are faking sick, or all of their employees are calling out at every turn. And a lot of times these clients have not formally set the expectations for attendance at the time of hire. There are many ways to write an attendance policy, but if you have one and it is clear and direct from the call-in procedure to the consequences, and you're going through it with employees at the time of hire, you are much less likely to find yourself with an out-of-control absenteeism problem. And also, just as far as hiring, making sure that you are asking the right questions in an interview to make sure that you're hiring people who are committed, who are trustworthy, who are honest, who are not going to lie to you, and you're not going to call me in 3 months after they've been hired and tell me that they're faking sick or taking advantage of PTO. You do have to watch those interview questions. Certainly do not ask any medical questions, any questions about families, children, child care, elder care, responsibilities, anything like that that would give information about a disability or marital family status, sexual orientation, anything like that in an interview question. So you certainly don't want to ask, is there any reason why you might be calling in sick? But when I say asking the interview questions, I mean really getting at the root of someone's moral code of ethics when it comes to being honest, when it comes to following your policies, and being loyal to the company. So point-based attendance policies, they have their benefits and their drawbacks. So point-based attendance policy, employees get assigned a fraction of a point up to multiple points based on an attendance infraction. So an incident of tardiness, an early departure, an all-day absence, a no-call, no-show, any type of absence from work, and points will accrue and then usually drop off after a defined period or a rolling period, or an employee will have to have a set period of good attendance to cause a point to drop off their record. You can have points drop off every January 1st and July 1st. You can have points drop off 6 months from the date that the point was initially incurred. There are a lot of ways to do that. Employees can game a point-based attendance system if points are within a defined period. For example, points drop off every 6 months. Your employees may take a freebie when the period resets. They could just be holding it together until a point drops off. And as soon as the point drops off, they're going to take another day. They're going to use up every possible absence without ever exceeding the number of points to get to termination, and just take unplanned personal days without consequence. Point-based attendance policies can be inflexible. They can lock you into a disciplinary system and take away your discretion. You may want to be done with someone who has an absence that is clearly hangover related in the middle of the week, but they don't have enough points to get to termination yet. If you skip ahead in the process and terminate them when they don't have enough points, this can lead to a discrimination claim. It can also get complicated if you're making unplanned illness 1 point and pre-planned medical appointments 0.5 point, if they don't have any PTO, and non-illness related absences 2 points, and throwing tardiness in there and counting multiple tardies as 1 absence, and making a no call, no show 3 points, but the point limit is 4. So someone who is sick and calls in 4 times gets fired, and someone who is sick 1 time but just doesn't bother to let you know keeps their job. Very, very complicated. With the making a no call, no show 3 points, and an absence as 1 point, and making the limit 4, you're going to lose someone who is way more reliable, but just may happen to be exposed to more germs over someone who doesn't care enough to call in and let you know when they're absent. So it can get complicated, and it can, again, lead to retaining someone who really doesn't deserve to be there, and passing over someone who's really trying to be a good employee. No-fault attendance policies. So no-fault attendance policies can protect you from discrimination if everyone's absence is just an absence, no matter what. Like the point-based attendance policies, this can stick you with bad employees and lose you good employees. If you just consider everyone's absence an absence, you could have someone who has unreliable childcare during a divorce, for example. It's not their fault. They're trying the best that they can. Someone else is making things difficult for them, and they're just trying to get through a brief period in their lives. But absences are absences and consequences are consequences. Then you could have someone who just cuts out early to go to the cabin once in a while. There's no fault. Both of those absences are considered equally, but which employee is possibly more valuable to the company. A reason-based attendance policy could also protect you from discrimination, kind of on the flip side. One thing I would recommend would be expanding the definition of family member if you're going to consider an absence related to a family member's illness as an excused absence. Give examples of what would be excused or unexcused, regardless of marital or familial status. Marital and familial status is a protected class in some states. So if you're expanding the definition of family member, you are including individuals with all family members, not just individuals with spouses or children. If you give examples of what would be unexcused regardless of whether you're married or have children, such as a sick pet, sorry, that's always going to be unexcused. It doesn't matter if you're married or not. Car trouble. Watch for a disparate impact. If you've got employees with public transportation issues, and you're making public transportation issues an unexcused absence. This could have a disparate impact. This could affect members, more members of one protected class than another, depending on who is taking public transportation in your workplace. So even if you are not intending to discriminate by making public transportation issues an unexcused absence, you've got to look at the outcome and who's being effective. And if the outcome looks discriminatory, then you need to back up and start over with that to avoid that effect. Obviously, you would allow all religious holidays as excused absences. You don't want to tell someone, oh, you know, well, Christmas is a day off for everybody, but I've never heard of your religious holiday, so that's an unexcused absence. Of course, you don't want to do that. So FMLA, this is where absences get complicated and can get legally tricky and can cause difficulty for employers. So absences that are covered by the FMLA may not be counted against an employee for the purpose of discipline or termination. Now, as we know, with FMLA, an employee can take FMLA when they're unable to work due to their own serious health condition or the serious health condition of an immediate family member. Now, serious health condition means an illness, injury, impairment, or physical or mental condition that involves inpatient care in a hospital, hospice, or residential medical care facility, or continuing treatment by a healthcare provider. Now, keep that in the back of your mind, because you're going to be on the lookout for a serious health condition, and you need to have that definition in your mind to know when your radar should go off when you've got an employee calling in with an illness-related absence. Employees can take up to 12 weeks of leave, so that's 12 work weeks for all employees, regardless of how many hours per week they work. It's a work week is a work week. But if you are going to have to calculate the number of hours so that you are counting it against intermittent leave hour by hour, you may calculate the hours based on regularly scheduled hours if the employee works fewer than 40, but it must reflect the number of hours in the work week. So if you are splitting intermittent FMLA up and you have an employee who works 40 hours a week, then that's 480 hours of leave that they have to use if they're taking it in small bits at a time. And if you have an employee who works 30 hours a week, they get 360 hours if they're taking leave hour by hour. If they're taking it week by week, it's 12 weeks for everybody, but if they're taking it hour by hour, you can have that reflect the number of hours they work in a week. Many states now have mini FMLA laws or even paid medical and family leave laws that cover much smaller employers than the FMLA and have much more inclusive eligibility requirements than we think of with the old dinosaur, the FMLA. So your inquiry should not stop here. Know your state. This is why we love to invite you to check with counsel. We practice in all 50 states here at my HR Council, and we know whether or not there is a leave law in your state that is going to protect these absences, even if you are not covered by the FMLA. So when you start the FMLA process, there are no magic words that an employee needs to use to start the process. Like I said, keeping the definition of a serious health condition in mind, if an employee is absent for 3 or more consecutive days, if they call in sick, or if they call in and mention a hospitalization, you need to get ready at that point. You need to start gathering more information, and you need to start the process. Now, if you gather more information, if they've called in for 3 consecutive days and they tell you, you know, no, I don't need FMLA, I just, you know, I have COVID or I have the flu and I'm going to get better by tomorrow, then that's fine. Then you asked, you covered your bases, and those absences are not covered or protected by any law, and you can just chalk those up to absences and move on. But if someone calls in sick, and it is a serious health condition, then it's on you. It's not on them to ask for FMLA. It's on you to start that process. And if an employee keeps calling in and saying they have a sick child or parent, and that's happening frequently, if an employee is making appointments for recurring medical appointments, or if they're having recurring sick days, if there's a chance that there may be a serious health condition or a family member's serious health condition, and that the employee may be FMLA or state family and medical leave law eligible, those absences, however small or infrequent they are, if they are covered under FMLA, they need to be covered and tracked. You must designate all FMLA qualifying leave as FMLA. Don't let an employee tell you they don't want to take FMLA or don't want to use FMLA. This is for your protection as well as theirs. If they say, look, I just have one doctor's appointment a month, I don't want it, and you don't designate it, and you later try to count those absences against them because they weren't covered by FMLA, you're going to be in trouble. Retroactively designating FMLA is very difficult. You don't want to help an employee out or be flexible for 6 months and then find that you have to add on another 12 weeks when you've had enough and you are ready to terminate. Also, federal law requires you to designate. Federal law does not give you a choice. You must designate FMLA if the absence is eligible or covered by FMLA. Continuous FMLA, we all know that that guarantees reinstatement, and the leave remains permanently protected. So that continuous FMLA is in a bubble. You can never go back and allude to FMLA in an attendance or performance warning. I mean, obviously you don't have to employ that person forever if they continue to have unprotected absences or performance issues, but when you reinstate, the best practice is just to start from zero, let them have a clean slate, and don't consider any absences that may or may not have fallen under the coverage. Just start over. Don't do things like say an employee can't go on the company picnic because they weren't there to plan it. Don't do or say anything that implies that the FMLA related absence was a burden or hardship of any kind. If you do or say anything that implies this, plaintiff's attorney is going to jump all over this as FMLA retaliation. Train your supervisors not to do this, and train your supervisors to keep coworkers from doing this, because even if you are saying, well, it's FMLA, so we can't discipline you for it, but it was kind of, difficult around tax time when, so-and-so had to pick up extra work. You don't want to do that. You don't want any kind of talk like that is going to be trouble for you. Intermittent FMLA, again, with FMLA, there is no undue hardship exception. You have to, if you are covered by FMLA or by a state law, you have to provide continuous or intermittent FMLA. It's not like the ADA where you can say, my business can't handle it. There is no exception. With intermittent FMLA, you can temporarily reassign the employee to an alternate position to make it easier to accommodate the reduced schedule or intermittent leave. Of course, there can be no loss of privileges or benefits. You can't reassign them to something that is less desirable. You can't have an office worker taking out the trash, but something equivalent that makes things easier with the absences. If you don't have anything, you have no choice. If you are a gas station with one attendant on duty at a time and your employee who is covered by FMLA gets a migraine 15 minutes before the start of her shift, if she is FMLA or state law eligible, that is your problem and cannot have repercussions for her in any way. You cannot make people on intermittent FMLA cover their own shifts or punish them for failing to find a replacement. So that in that case, that employee getting a migraine 15 minutes before the start of her shift, I'm sorry, the government requires you to do the scrambling in that case. If you let people take vacation in 15-minute increments, you must let them take intermittent FMLA in 15-minute increments. In any case, you cannot require employees to take intermittent FMLA in more than an hour. If they have a doctor's appointment that's going to take an hour and a half, you cannot make them take 4 hours of intermittent FMLA. Recertification, it cannot take place more often than every 30 days, or if the nature of the leave has materially changed from the original certification, which means no requiring a doctor's note for every absence. But if you have an employee on intermittent FMLA and they are taking the FMLA as in the Friday, Monday Leave Act, you can contact the healthcare provider and describe the pattern of intermittent absences you are seeing day before, day after a holiday, and day before, day after a weekend, 4 times a month. And you can ask whether that is therapeutically necessary. You can ask whether that particular pattern of absences corresponds with the nature of the serious health condition. With intermittent FMLA, if you have the must work the day before and the day after the holiday to get paid for the holiday, you must make an exception for intermittent FMLA and let them get paid if they miss the day because of intermittent FMLA. Intermittent FMLA is not working from home. These are two diametrically opposed concepts. If an employee has a serious health condition, but is able to work from home during a flare-up, then they should not be using FMLA. FMLA means unable to work. Do not count intermittent FMLA hours for anyone who does any work while they are at home. If they perform any work, do not subtract that from their total allotment. And don't ask anyone who calls in with an intermittent FMLA absence to do any work while they are out. That, again, will cause trouble. The call-in procedure. So I hear this all the time. So do I have to just let them not show up? No, they are still a grown-up and this is still their job. With continuous FMLA, don't require the daily call-in. Checking on them too frequently could be FMLA interference. With intermittent FMLA, you can require a call-in for every absence. You can discipline or terminate for failure to follow the call-in procedure. Again, you can't discipline or terminate for the absence, but if they're not calling in and they're just not notifying you, you can get them on the call-in procedure. Be reasonable. If they're vomiting and they can't get to the phone until 7 minutes after the shift starts, don't give a final warning for that. But yes, they do have to follow the call-in procedure, and yes, you can discipline or terminate on the call-in procedure. ADA is another reason for absences that are protected under law, and another reason that trips employers up when they are trying to deal with someone who is having an attendance problem and would like to terminate them for being unreliable, but there may be a hidden reason why doing so is going to spiral into a lawsuit and a big payout for you if you make a misstep. The ADA applies to employers with 15 or more employees, but most states have equivalent laws with lower employee thresholds. So depending on your state, this could cover you if you have 1 or more employees. It is significantly lower in most states. So the definition of disability. As you can see here, this is a pretty long list, and we will send out the deck so that you can take a look for yourself and go over this. But you can see that it's an impairment that substantially limits 1 or more major life activities or major bodily functions. That's the definition of a disability under the ADA. You can see on here a major life activity includes working. If an employee's impairment is substantially limiting them from working, and if it wasn't substantially limiting them from working, they wouldn't be on your radar at all, then they meet the definition. So it's going to be more rare that they do not have a disability than that they do. So this definition, what does this include? This includes migraines, asthma, depression, anxiety, irritable bowel syndrome, insomnia, diabetes, PMS, ADHD, lower back pain, fibromyalgia, alcoholism, or recovery from chemical dependency. It does not include active illegal drug use, however. How does this relate to attendance? We'll get to that, but start thinking about employees who have called in and asked for an hour or a month or more off due to one of the conditions I just mentioned. Then start thinking of all of the all of the other call-in reasons you have heard in your time as an HR representative or business owner or other management personnel. Think about all the other reasons you've heard and look back at the list when we send you a copy of the deck and you'll see that it's a pretty big umbrella. Don't worry, an ear infection, a sprained ankle, a stomach bug, cold, flu, COVID, if it's just the standard 10-day COVID, strep throat, not a disability unless it becomes one. Most people are not limited to a degree or for a length of time that one of those conditions could be said to be substantially limiting. So the purpose of the ADA, as stated in the law, is so an employee with a disability can enjoy equal employment opportunity. FMLA is great for a lot of things, but some employees will experience lifelong conditions that don't always allow them to be at work all 40 hours every week, 52 weeks a year. Should these employees be limited to working for large employers who have to give them FMLA? What if they can't wait the 12 months to be eligible for FMLA? You wouldn't allow a mobility impairment to hold an employee back at work. You would make the workspace accessible. Just the same, you shouldn't allow other impairments to hold employees back at work just because their particular impairment causes time away from work. I don't think of the ADA as punitive, as forcing you to tolerate an employee who has to call off work. Think of it as a way to encourage all employers to retain some great, loyal employees who maybe would have otherwise fallen through the cracks. So countless research has shown that people want to work at and will actually accept lower compensation and benefits to work at companies that value diversity and have a compassionate company culture. So your non-disabled employees and candidates are watching the way you treat your employees with disabilities. This should be an incentive for you to follow the ADA, to be up on the ADA, to be looking for ways that you can interpret the ADA to be as generous as possible when it comes to attendances. This is your company culture. You want to retain top talent. You want to retain top talent that's willing to work for perhaps less money. Here's your chance to do it. So the interactive process, some of you may ask, so if an employee calls in and says, I need to be absent, I have a disability, do I just take their word for that and let them run with it? No. You go through the interactive process. This involves getting more information from the healthcare provider to prove the existence of a disability. So you do not have to take their word for it that they have arthritis or diabetes or whatever. You can get information from the healthcare provider and getting an idea of what accommodations will work. Now, you can't ask for repetitive information. Sometimes with a workers' comp claim, you may already have the diagnosis and restrictions. Don't go double dipping in that case. You can't ask for more than you need. Don't ask about other conditions that are not causing the absences. And then part of the interactive process is a back and forth discussion about what accommodations may enable the employee to perform the essential functions. So having an open back and forth discussions about what their schedule might look like, what planning and unplanned absences may look like, how you're going to accommodate if there are potential attendance issues. just coming at it a place from really being open to discussing this, and not coming at it from a threatening place or a place of trying to squeeze as much out of the employee as you can, but being open and being creative. And how is this going to look? You've got this employee, you get the information from the healthcare provider. It says may have flare-ups, may need medical appointments. Talk together and be creative and think about what you can do. Now, the employee does not get to pick the accommodation as long as the accommodation that you provide is reasonable. If you can provide an accommodation that effectively enables them to perform the essential functions while they're at work, so if you can come up with something that allows them to do their job while at work, you don't have to give them continuous or intermittent leave just because they say they want that. Now, if an employee has an illness that requires medical appointments or flare-ups where they just are totally unable to work, yes, you have to accommodate that. But if there is something where an employee can be moved to a quieter workspace with lower light and is still able to work, you don't have to give the employee the whole day off if they don't need it. That's going to depend on the information that you get from the healthcare provider, but you can certainly verify that with the healthcare provider. So starting the interactive process, again, just like FMLA, there's no magic words. You're on alert. You're on the hunt for whether there may be a qualifying disability that may need to be accommodated by the ADA, and whether those accommodations will involve continuous or intermittent leave. Don't hide your head in the sand. Again, if an employee calls in and says, I'm sick, I'm sick, I'm sick, and does not give you any details, do not assume that they do not have a disability because they did not mention one. And don't proceed with termination saying, well, they violated the attendance policy and they never requested an accommodation. That's not going to save you. It's on you to ferret this information out. If somebody calls in and says they're sick, again, you can't ask employees medical or disability related questions. So if an employee calls in sick once, interrogating that employee is not a good idea. However, if you have an employee who has difficulty performing the job, and difficulty performing the job can include difficulty with regular attendance, you can and should offer reasonable accommodation. If you have an employee who is having an attendance problem and is calling in sick, you can ask, hey, I see you've been absent a lot. Are your absences related to a medical condition or disability? If so, we would like to begin the process of providing you with a reasonable accommodation. Now, the employee can say no. The employee employee can say they don't need an accommodation. They can refuse to give you any medical information. In that case, they've abandoned the interactive process, and you don't need to accommodate an employee who says, no, they don't need an accommodation, or no, they're not going to give you any information to verify the existence of an ADA-defined disability. If they say no and they refuse to participate in the interactive process, you don't have to accommodate at that point, and you can go ahead and count those absences against you. Once you have tried, you have to try, you have to reach out your hand. If the employee doesn't take your hand, then you can proceed, but you do have to make the effort on your part first. If your employee tells you that it violates HIPAA for you to ask them for information or give them an interactive process questionnaire and ask them to have their doctor fill it out, most likely you are not a covered entity by HIPAA, and they are wrong and they do not understand what the law is. If you have questions about this, certainly open a ticket and we will help explain it to you, but you are definitely within your right to ask for more medical information. Again, you can ask employees medical or disability related questions. unless you are providing a reasonable accommodation. You can provide a reasonable accommodation if the essential functions are not being done and discipline or termination is imminent. So this is, if you're going to provide a reasonable accommodation and you want to verify the existence of a disability and find out how it affects essential functions, that's when you ask for the medical information. If an employee is sick one time and it's not going to result in discipline and it's not going to result in termination, don't require them to tell you what they were sick with if it does not matter. That's asking for medical information you don't need, and that's going to violate the ADA. I'm talking about if an employee has had 5 absences and you're ready to pull the plug, stop before you do so. Reach out to the employee, find out if these 5 absences have been caused by a disability and if you need to accommodate by making an exception to your attendance policy for this particular employee. That's the point where you would need to get involved and start looking at the medical information. You know, if you've got an employee who's sick once, don't ask for their whole health history. That's going to violate the ADA. Is it reasonable? So regular attendance at work is not an essential function of all jobs. And it is an essential function of some jobs. So if you operate a group home with a required staffing ratio, or if you operate a security station that's staffed by only 1 guard at a time, and you could not operate your business if your employee was periodically absent on short notice, then regular attendance at work is an essential function of that employee's job. If you work in an office and work is ongoing and can be shared, regular attendance is probably not an essential function of that job. Of course, yes, everything runs more smoothly when everybody shows up all the time, but when it comes down to making an essential function of the job, it's really going to be fact specific there. If it is going to be an essential function of the job, if regular attendance at work, showing up at work on a regular basis, not intermittently, if that's going to be an essential function, it has to be in the job description so that the healthcare provider can see that when you give them the job description with the interactive process questionnaire asking for more information. So make sure you have that in the job description. Length of time that is reasonable varies fact specific. Even if they're not eligible for FMLA, 12 weeks can still be a reasonable accommodation. If they are eligible for FMLA, 6 weeks beyond their FMLA can be reasonable. Will the additional time effectively enable them to return to work? If you've got an employee who needs 90 days of chemical dependency treatment plus 6 weeks of aftercare as directed by a healthcare provider, that can be reasonable. 18 weeks to recover from a car accident can be reasonable if a doctor can give you an accurate prognosis and advise you of needed recovery milestones that the employee needs to reach to come back to work. A court has found that a 7-month ADA leave is reasonable in one case where it was a recovery from an accident, and the healthcare provider said the employee would definitely be better and able to return to work as soon as broken bones healed and casts came off. That is 7 months is pretty extreme. Indefinite leave with no projected return to work date is not reasonable. Letting somebody languish on leave with no guarantee whether or not they'll ever be coming back to work, that's not a reasonable accommodation. You do not have to allow that. Unlike FMLA, ADA does have an undue hardship provision, but it is a very high bar to clear. If you can hire a temp or redistribute their work for 8, 10, 12 weeks, you have to do it. Undue hardship means it negatively impacts your bottom line or fundamentally alters the way you conduct business. One note here is you cannot consider employee morale in making your decision. So you can't consider employees who complain Carol's gone all the time, and you actually must prevent any of these complaints to avoid violating the ADA. So again, you need to train your supervisors not to express any dissatisfaction with someone who is gone on ADA-related absences, and to prevent their coworkers from also making these types of comments. So undue hardship does not include the fact that, hey, our other employees think it's unfair that this employee gets absences. Hey, our other employees are calling in sick more because they think they should get to. Unfortunately, that is not considered as part of the undue hardship analysis. And if you try to hang your hat on that as far as undue hardship, you're going to be out of luck. So managing ADA leave, as we said, it violates the ADA to ask for repetitive information about the medical condition or disability, or information that you already have. So you can require a doctor's note for every absence to show that the employee did need to be absent due to the disability. You can ask for a note to show that the absence was disability related. But you cannot ask for repetitive information or information you don't need. So if you are accommodating with intermittent absences, do not ask for a detailed doctor's note every time. Don't ask for medical information that relates to something other than the disability that is being accommodated. If you are accommodating someone and they have an absence for a different reason, treat them like everyone else, and do not ask for more medical information from them just because they have a disability and you are accommodating them for that reason. And don't ask for any more details than you need. You may have an employee who has asthma, and you don't need to ask about what medications they're on and whether there are other medications that would better manage their asthma, and whether they could show up at work more if maybe they switched to one of those medications. You're going to get in trouble with the EEOC if you start asking for that level of detail or trying to interfere in the employee's treatment like that. The call-in procedure, once again, just like with FMLA, employees taking ADA leave or having intermittent or continuous absences as a reasonable accommodation under the ADA still have to follow the call-in procedure. So even if the reasonable accommodation is intermittent, unplanned absences, they still have to follow whatever your policy is for call-in notification of an absence. Unless the disability prevents the employee from using any method of communication to contact the employer, or directing anyone else to use any method of communication to contact the employer on their behalf, not calling in is not part of the accommodation. Now, to say with a disability like epilepsy, where an employee may lose consciousness for a period of time and get taken to a hospital, perhaps something happens publicly, they lose consciousness, someone calls EMS, they get taken to a hospital 20 minutes before their shift is supposed to start. Take this into consideration. Don't be unreasonable with this, and hold them to an ironclad, obviously. But no, not calling in is not part of the accommodation, and this applies to employees with depression or anxiety who may not necessarily feel like calling in. I suppose if the healthcare provider gives you information on the interactive process questionnaire that says has flare-ups where they become totally unable to use any method of communication or direct anyone else to use any method of communication, then you may have to start thinking about making a reasonable accommodation to the call-in policy, but I would question that. I doubt that's going to happen. Pregnancy leave. So the Pregnancy Discrimination Act, like the ADA, requires reasonable accommodations, but for pregnant employees instead of an employee with a disability, and this may include leave. like the ADA. You can't force a pregnant employee to take leave. However, if another accommodation is available, so you cannot, if other accommodations are available, including more intermittent absences, you can't say, no, we don't like having you come and go. We're just going to send you home until you have that baby, and then you can come back. No, you can't do that. You have to allow the intermittent absences. A pregnant employee might have more medical appointments than your average employee. Keep this in mind. You have to accommodate a pregnant employee. You may have to make an exception if you've got a policy that says medical appointments are unexcused absences. With a pregnant employee, they're gonna, if you're using a point-based attendance policy and giving points for medical appointments, they're obviously gonna run up points faster than another employee. You may want to make an accommodation to that if they are pregnant to comply with the PDA. Paid sick leave. So this is something that is most likely either in the location where you operate or near the location where you operate. And the three areas here have not just a paid sick leave law, but a paid leave law for any reason that provides protected leave, where an employee can call in and say, hey, I'm taking the day off. But with paid sick leave, the general rule is if they have it accrued, you must let them take it. Even if taking the paid leave or paid sick leave violates your point system, if your point-based system says termination occurs at 7 points and the employee has 6.5 points and calls in and requests the day off, and they have paid sick for illness, and they have paid sick leave available, I'm sorry, that may violate your attendance policy, but you cannot terminate them or discipline them at that point. You cannot do anything to discourage paid sick leave absences, nothing that would threaten or deter an employee from taking a paid sick leave absence. So nothing to even give them the idea that a paid sick leave absence may be held against them in any way. General paid sick leave requirements, no requiring them to cover their own shift. You can ask them to schedule appointments during non-working hours, but if they do schedule an appointment during working hours, if they have the leave, again, you must let them take it. The 3-day doctor's note rule is fairly universal. You can only require a doctor's note after 3 days of consecutive absence. And this should also be your FMLA trigger. If they're absent for 3 days, getting that doctor's note and saying, hey, you've been sick for 3 consecutive days. Is this a serious illness that you're going to need FMLA for, or you're having some issues with attendance? Do we need to provide you with a reasonable accommodation? The note that the doctor's note, however, that you require under paid sick leave can only say that the leave was used for a purpose under the law. You cannot require them to be more specific. If it says, yes, this leave was used for one of the reasons listed in the paid sick leave law, then you're good, and you cannot ask them to go any further or any more specific than that, no matter how suspicious you may be. If you have proof that an employee was not using paid sick leave for a purpose listed under the law, if you have a Facebook post that clearly shows the employee doing something else during the time that they were taking paid sick leave, if you have an eyewitness account of the employee doing something else other than taking sick leave for the intended purpose under the law, you can deny the use of the paid sick leave and count the absence against them. If the employee is requesting paid sick leave after they requested vacation or PTO and had that request denied, that may be something that should lead to an investigation. But ultimately, if all you have is their word, you cannot give points for a paid sick leave absence or use it as the basis for discipline. Again, if you have proof and you are going to use an absence where they requested paid sick leave against them, you must have very strong documentation. Now, some of these laws are backed by big bucks, and just a small violation can cost you some serious money. So make sure that that you are not disciplining or terminating for any of these covered absences, or doing anything to discourage. Every jurisdiction sets its own minimum increment for using paid sick leave. Most require you to, again, to use the smallest increment you use to measure time. If you let people use 15 minutes of vacation, you can't require them to take paid sick leaves in 4-hour chunks. If you do not separate PTO and paid sick leave, if you have one PTO policy that is more generous than what the law requires for paid sick leave, and you use that to cover everything, you do not control it now. If an employee has a covered reason, they can take it on demand in the minimum increment. So just because it's now covered under your PTO policy instead of a separate paid sick leave policy, if they call you up and say, hey, I'm sick, then that absence is covered and you cannot discipline or terminate them for that absence. However, if you have one PTO bucket that is more generous than the paid sick leave law, and it covers paid sick leave and vacation all in one. If they take all of this PTO for vacation in January and the bucket is empty, you do not have to give them additional paid sick leave if they get sick. If it's in one bucket and it's all gone, it's gone, and you, regardless of the reasons for discipline or regardless of the reasons for absence, you can discipline them for absences after that once it's gone, other than, as we discussed, the FMLA, the ADA. Make sure your payroll provider can track accrual and use of paid sick leave. That's not an absence-related advice, but make sure your payroll provider is tracking accrual and use if you don't want to be subject to a huge claim against you. That's just a quick note. Jury duty leave. Again, know your state, because whether or not you can and how you can treat an absence related to jury duty is going to vary from state to state. But in every state except Montana, which is the notorious outlier, you cannot count a jury selection or jury service absence against an employee. No points can be counted against an employee for time spent on jury selection or jury service. If they go for jury selection, if their workday is 8 a.m. to 5:30 p.m. and they go for jury selection and get dismissed at 9:30 a.m., you can tell them they have to come straight back to work, or it's going to be an unexcused absence if they take the rest of the day. That's fine. If it's reasonable. Obviously, if they get dismissed at 4:30, don't say, oh, you have to come back here at 4:15 and work the last, or 4:45 and work the last 15 minutes of the day. Be reasonable with it. But if they do get dismissed from jury selection or service early enough for there to still be a significant portion of the workday left, you can counted against them if they do not come straight back to work. You do not have to let them take the entire day if the jury selection or service only takes a small part of the day. Some states, employers, and I hear about this a lot, I do get requests for drafting letters to the court to excuse the employee based on business needs. In some states, the employer can request it. In some states, they say no, no way. We don't care what your employer wants. But unless you're in Montana, you cannot penalize them for serving. You can't force an employee to say they can't do it, or cause them to incur some sort of consequence from the county or the state because you don't want them to serve on a jury or you don't want them to be absent, you do have to let them do that. Voting leave. So this is, I think a lot of people think that federal law requires you to give employees time off to vote. That is not the case. It is 30 states that do require time off to vote. The other 20 do not. Know your state, check with counsel. I say it again, that's why we're here. That's why we practice in all 50 states, is because we do know the answer when election time rolls around, and this applies to all elections, federal, state, municipal elections. Some states specify the number of hours that an employee can use for voting leave and have that be a protected absence. Some states say a reasonable amount of time, so you couldn't count, issue points or start counting for discipline, anything until the time used became unreasonable. That's kind of a slippery slope. I would say be very careful there. Some states like New York and Texas say your employee gets as long as it takes, and you don't get to have a say in how long they can be gone voting. If it takes all day in New York or Texas, it takes all day. Some states like Nevada get very specific and start counting the miles from work to the polling place and calculating time based on that. It's all going to vary based on your state. Generally, you can require employees to take that leave at the beginning or the end of a shift. But you can't give attendance points for voting or call these employees unreliable or use this against them if they do it within the state law's parameters. Small necessities leave, just very quickly. Some states prohibit discrimination on the basis of marital and familial status, as we said at the beginning, and federal law prohibits discrimination on the basis of sex. However, women are disproportionately likely to be caregivers, which makes women disproportionately subject to attendance violations. That is a disparate impact. You should not have that happening. You should not have women being disciplined or terminated for attendance more often than men because they are more likely to be staying home with a sick child or caring for an elderly relative or attending school conferences, something like that. You can't have a policy that says parents get 3 weeks of PTO, non-parents get 2 weeks of PTO. That would be discriminatory. But excusing absences for caregiving and expanding the definition to caregiving for any family member is non-discriminatory, and it does help employees with caregiving responsibilities succeed. S&L laws cap hours, and your policy can as well. This doesn't mean allowing employees to work 20 hours a week because they're taking a half day every day, taking a cousin or great aunt to the DMV, but being reasonable and leveling the playing field for caregivers. So in conclusion, it's okay to call absenteeism or tardiness excessive or unacceptable when you have an articulable, non-discriminatory, non-retaliatory reason for doing so. You do need people to be there to get the job done. But ignorance of these laws that we discussed today and other state leave laws that are too numerous to mention here, check with counsel, know your state, be prepared for the excuses your employee provides and run them by us. If you are not a client of ours, please go to myhrcounsel.com, check out the packages that we offer and see if we can help you with assistance in controlling absenteeism in your company. Draft your policy, make your expectations clear from day one, discipline as you go so that there are no surprises after a string of absences. Look for the landmines, FMLA, ADA, like we talked, and document some more. As we always say with any type of employee issue, the more documentation you have, the better. And thank you all for being here today.
Thanks very much, Britt, and thank you to everyone who stayed with us for the whole hour. We greatly appreciate your continued interest in our monthly webinar series. And as Britt mentioned, if you're a client of ours, we do strongly encourage you to reach out to us through the Ask an Attorney portal. And if you're not a client of ours, feel free to to look at our packages. Our Ask HR services can be found at mytrackcouncil.com/packages. You can get started for $99 per month. And with that, you would get unlimited access to our attorneys to ask any of these attendance-related questions. We give you practical advice within our guaranteed response rate of 2 hours or less. So thanks again, and we will send out the follow-up email tomorrow. And that's going to include the recording, the slide deck, as well as the HRCI credit. We look forward to hosting you again in our May webinar. And thanks again.